You know that feeling? You shake on a deal, you sign the contract, you think everything's locked in, but then the other side just backs out. What happens when a promise gets broken? Well, today we're going to get into exactly that, the legal options you have when a deal goes wrong. Let's dive right in.
I mean, just imagine this for a second. You finally find your dream house. Or maybe it's a one-of-a-kind classic car you've been hunting for years. You've got a signed contract, and then, at the very last minute, the seller gets cold feet. A simple sorry and your money back just isn't going to cut it, is it? You don't want the money. You want that house or that car. So what can the law actually do for you?
Well, when a contract gets broken, the law basically gives you two very different ways to get justice. And it's not always about a financial payout. Sometimes it's about forcing the other person to give you exactly what they promised in the first place.
And this slide really lays out those two paths. On one side, you've got damages, which is just the legal word for money. It's the standard go-to solution for most broken contracts. But on the other side, you have something much more interesting. Equitable remedies. These aren't about cash at all. They're about a court ordering someone to do something or to stop doing something. And they're only brought out for special occasions, when money just isn't enough.
And this right here, this quote from a famous case, is the golden rule for this entire topic. It's the whole foundation. These powerful, action-based remedies are kept in reserve, only for those unique situations where throwing money at the problem won't actually solve it.
So let's dig into the first of these special remedies. This is the big one, the one that basically says to someone, look, you made a promise in a contract, and now the court is going to make you keep it. It's called specific performance. So what does that mean in the real world? It's a judge looking the other person in the eye and issuing an order that forces them to do exactly what they agreed to do. Hand over the keys to that house. Deliver that one-of-a-kind painting. No excuses.
Okay, so how does a court decide when to use a tool this powerful? Well, especially when we're talking about physical objects, it almost always boils down to this one simple question. Is the thing you were supposed to get truly unique? Or is it something you could just go buy another one of down the road?
And these two old cases show this test in action perfectly. In the first one, a guy bought a house that had this incredible, ornate, Adams-style door. The seller removed it before the sale went through. The court said, nope, that door is unique. Put it back. And they had to. But in the other case, with some antique chairs, the court said, look, they're nice chairs, but they're just merchandise. You can buy other antique chairs. So they only awarded money. It's a really fine line, isn't it? All right, so if specific performance is the make them do it remedy, what's the flip side? What if you need to stop someone from doing something? Well, for that, we have the stop them doing it remedy, which the law calls an injunction. You can basically think of an injunction as a restraining order for a contract. If your agreement has a clause where someone promises not to do something, an injunction is the court's way of making sure they stick to that promise. And the real-world stories here are just fantastic. Way back in the 1850s, an opera singer had a contract with one theater but tried to go sing for their rival. The court issued an injunction to stop her. And much more recently, a top jockey was about to ride a competitor's horse in the famous Epsom Derby, and a court stepped in and stopped him because of his contract. Now, here's the really subtle but crucial part. A court will almost never force that opera singer to actually get on stage and sing. That feels a bit too much like forced labor, right? But what they will do is stop her from taking her unique talent to the competition. They'll enforce the negative part of the promise, even if they won't enforce the positive part. Okay, these remedies sound amazing. They're like legal superpowers. But here's the reality check. They are definitely not handed out like candy. The courts are really careful about this, and there's a whole checklist of reasons they might just say no. For starters, if money really would be a perfectly fine solution, the court will just stick with that. They'll also say no if enforcing the order means they'd have to constantly supervise it. Judges don't want to be project managers. And of course, they won't grant an order that would cause unbelievable hardship to the other person. And my favorite one, the unclean hands rule. If you've acted shady or unfairly yourself, you can forget about asking the court for this kind of special favor. All right, let's shift gears from these big court battles to our everyday lives. Because for most of us, contract problems happen when we're just buying stuff. And thankfully, especially here in the UK, the Consumer Rights Act gives us all some very clear power-ups. So picture this. You buy a new gadget and it's dead on arrival. A new shirt that has a hole in it. You don't have to just meekly accept whatever the store offers you. The law gives you a very clear roadmap, a hierarchy of rights to follow. Right off the bat, for the first 30 days, you have what's called a short-term right to reject. That means you can take it back and demand a full refund, no questions asked. If that window passes, your next right is to a repair or a replacement, and if that doesn't work or isn't possible, then you get a final crack at rejecting it. Or you can keep the item and get a price reduction. It's a really clear, powerful process. But hey, it's not just about things you can hold. What if you hire a plumber who makes the leak worse, or a web designer who delivers a broken website? The law's got your back there too.
Your first legal right is to demand that the trader does the service again, properly this time, at their own expense. Now, if that's impossible, or they still can't get it right, then you move to step 2, the right to a price reduction, and that reduction can be anything up to a full 100% refund.
And in today's world, so much of what we buy isn't physical at all. We buy software, we download games, we stream movies. So what happens when that digital stuff is faulty? Yup, the law has kept up.
You'll probably recognize this pattern by now. Your first port of call is the right to a repair or a replacement of the faulty digital content. And if that doesn't fix the problem, you then have the right to a price reduction. So your digital purchases are just as protected as physical ones. And that really is the most important thing to take away from all this. Whether you're dealing with a priceless piece of art or just a buggy app on your phone, your rights often go way beyond just getting a refund. You often have the right to demand what you were actually promised in the first place. Which really just leaves us with this final question to chew on. At its heart, contract law is about fairness. It's about making sure promises mean something. And it forces us to think, when something goes wrong, what does it truly take to make it right? Sometimes it's about a whole lot more than just the money.